Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who've been board certified in family law by the Texas Board of Legal Specialization.
Welcome, everybody. Thanks for tuning into the For Better or Worse or Divorce podcast, where we provide tips and insights on how to navigate divorce and child custody situations. I am Ryan Segall, and today I am joined by my colleague and esteemed associate, Jessica Davis, from our San Antonio office. Jessica and I are here to discuss mediations in family law. We're both certified mediators and family law attorneys here at Walters Gilbreath. Thought it'd be nice to chat with you, Jessica, about mediations and what that is here in the family law world and how it can help people resolve their disputes. So welcome, Jessica.
Thank you. And thank you for having me. It's my first podcast.
Ever? Is it your first one ever? Wow.
Ever.
Okay.
Yeah, I've done some talks, but never podcast.
Well, I'm sure you will knock it out of the park. So give the people out there in the podcast world, give them a little bit of background on yourself and how you got to where you are today.
So my name is Jessica Davis of counsel at Walters Gilbreath. I have known Jake Gilbreath for a long time. I think the whole time I've been practicing law. I've been a family law attorney ever since I got out of law school. So I think that's longer than I care to admit, but maybe 9 years now. So I've been doing lots of kind of complex high net worth divorce cases ever since I got out of school. And Jake and I have worked together in the past, and now I'm of counsel at Walters Gilbreath. And I have been to, I don't even think I could put a number on how many mediations I've been to. I tried to think. It's definitely in the couple hundreds. So it's a lot. It's a lot of mediations. So I got certified to be a mediator last year. And so looking forward to hopefully shifting to the mediator role on some of these.
Congratulations on your mediation certificate. I know you and I had talked before this, and I recently got mine, and I think we ended up going to the same certification school on that. And yeah, I mean, myself, I have handled countless mediations. When you fill out your board certification application, you have to list them all. And I mean, there was a lot to go through. And so, I like to say that I'm probably in the hundreds, maybe.
Yeah, I think it's a lot. I mean, because we mediate every case before we go to trial, sometimes twice if we mediate temp orders. So it's definitely a lot. I feel like mediation is such a useful tool, but I think sometimes it's a little misunderstood because I think people feel forced to go. But I, for one, am always staggered by the number of cases that do settle in mediation, even ones where I would go in and tell you there's zero chance this is going to settle today. I feel like I get proven wrong so many times.
Yeah. So in touching on that, because it's the same up here in the DFW area, in that most of the courts, if not all the courts, require you go to mediation before final trial. Some won't even hear your case if you don't go to mediation. Others, you'll get a limited time. You may get 1 hour aside or something like that. So I understand why courts are doing it. They're trying to get cases off their docket. But, from your perspective, how has how's that mediation kind of tied in to, when you're going to use mediation, when you go to mediation? You mentioned, you go to mediation for temp orders sometimes. Kind of, how do you determine when you're going to go to mediation?
Sure. So I think it's a little different in each of the counties we all practice in, and I overlap a lot. I mostly practice in Travis County and Bexar County, where we don't have that requirement for temporary orders to go to mediation, but Harris County does. So I feel like I kind of have seen a little bit of different approaches to this. I've always felt like temporary orders, sometimes I get frustrated with the mediation requirement just because I do feel like some things are so time sensitive and it does delay that hearing. But
I don't even know how it works, to be honest, on temp orders. I mean, if you have an emergency.
Yeah. And sometimes I feel like, what people want is so divergent in temporary orders that mediation is not helpful. I find that mediation for temporary orders is the most helpful when the parties just aren't communicating really well, and adding in that third party person to kind of work as a go between and get everyone working on it at the same time is really helpful. Like if there's just, they can't communicate very well or don't want to, which is very fair, right? And we just need to kind of get everyone sitting down and focused on the same issues at the same time. I think that's when I find mediation to be the most helpful for temporary orders. On final, like for a full mediation on our cases, like we do in every case before we go to trial in all our counties, I think that every case should go to mediation. And I say that because I have truly had cases where I thought there was absolutely zero chance that we would settle that have settled in mediation. And I feel like even at the cases that don't settle, people have a sense of, I've done everything I can, right, before we go to court. And I think that that kind of gives everyone some peace of mind, because we all know that trial has the unfortunate, I think, effect of having a long-term impact on people, like, you know, in their relationships in a way that is not what anyone really wants, right? Like, and so I think if things can settle at mediation, we give it our best shot. It's worth a try in every single case. I don't ever think it's a waste of time or money. And I think it also narrows the issues a little bit too. Going into trial, it makes it more streamlined.
There's a couple things that I want to touch on that you talked about. So number one, I agree with you. There's a, hey, we reached a settlement, like we can at least agree on at least one thing and start from there. I had a mediation recently in which a client said, you know, I know that she's never going to get what we're offering at final trial, but I'm willing to give it to her just to have some sort of amicable relationship going forward. And so, yeah, you know, going to court and putting people on the witness stand and attorneys cross-examining them, yeah, it's not going to be pretty. It never is. And people are going to come out of that probably disliking each other. Yeah, I mean, that's just the nature of the business. Whereas in mediation, not only do you have this, you know, it's a way to resolve the case amicably, but I also think it helps, and we can kind of speak on this not only as attorneys representing clients in mediation, but also as the mediators themselves. I think it helps to have that third party input on a case of, hey, here's what could happen if you go to court. Because, you know, in my experience, sometimes it's the opposing parties, sometimes it's the opposing counsels who are creating this divide between the parties. And it may be beneficial to have a mediator come in and say, hey, this is what's going to happen, because an attorney may be telling their client one thing, and a mediator may have a very different opinion as to, hey, here's your risks of going into court, and here's how we can settle this case.
Yeah, I absolutely agree with you. I think that having an experienced mediator who can offer opinions can help to reinforce, like, and keep everyone kind of back in reality sometimes where people have strayed. I also think there's value to like hearing another person saying it, right? Like you have your lawyer and of course you trust them and you have a great relationship, but sometimes I think that second opinion can really help put things in perspective. Another reason I love mediation and mediators, especially, is because I really think it's like the two heads are better than one approach. Like so often in mediation, we can come up with a creative solution to a problem that can make everyone a lot happier. And I always try to explain this, like judges are getting just the very top of the facts of like the life of your life and how it all works together. And they're going to come up with just solutions that aren't tailored necessarily to what's going on in your life. They have these kind of broad strokes approaches to possession and access and support. And I think that rights and duties, and I think in mediation, we can address things a lot more specifically and in a detailed and creative way to help fit our clients' lives that judges just don't have the time to devote to every case to do. And so I think that, you know, having a person who can kind of say, hey, in my experience, this is what a court's going to do is really valuable, but also kind of having another mind that's there to say like, hey, maybe you guys haven't thought about approaching this issue this way, or what about this possession schedule or this support schematic, you know, I think that that's really helpful.
I certainly agree with you on the creative aspect of mediation that you're never going to get in trial. I mean, trial is a judge is most likely going to rubber stamp possession schedule, one person's primary, that's that. Or as far as property goes, they're probably just going to order some sort of 50-50 or some sort of percentage split, and that's going to be that. Whereas, and especially when there's a house involved, court's probably just going to order the house to be sold. Whereas mediation, you can work creative solutions. One party can live in the house for a year and pay rent or whatever it is, and you can kind of work for the best of everybody to try to get something done. So I hear what you're saying on that, and I agree with you. Talk to me about a little bit about prepping for mediation. How do you do it? What's your approach? What do you kind of get your clients to do?
So I am team more preparation is better.
Hold on, is there a team that's no preparation?
From my experience in attending mediations, there has to be a team.
That's fair. That is
definitely times where I feel like I'm waiting an awfully long time for that first offer.
That is fair.
More prep is better. I was actually just thinking about this. So I draft a lot of orders for our firm, and I feel like there are so many cases where having a mediated settlement agreement that's not specific cuts against us. We end up arguing on the back end about terms if they're not laid out. So I feel like now, I used to say like, okay, just have a spreadsheet updated. I always have a call with my clients and say like, this is how mediation works. It's a binding, irrevocable agreement. Like, be 100% sure before you sign it. If you're tired, if you're emotional, if you don't want to sign it that day, there are options to maybe like come back for a second day. Because we can't undo them once they're signed. I kind of always have that conversation early because I feel like it's really important. I also tell my clients, like, write down the 3 things that are like non-negotiable for you so that we can do a gut check at the end of the day. That's just like, if we've compromised on one of those 3 things, are you sure that you're like ready to sign that? Or have you just had a really long day and do we need to table this and come back later? So I always tell them that just to kind of keep things in perspective. And then I always do a spreadsheet with all of our assets and liabilities on it. I always update it the morning of because I got the number of times clients have had like auto payments process overnight too high for
every time
that like credit card payment goes through and the bank balance is wrong. So I always make them, they're always probably annoyed with me, but I'm like 8:00 in the morning, you need to be sending me screenshots of your accounts. And then I like to do like a pretty specific parenting plan now because I just feel like so many things get lost in the details. If you do kind of just go in and say like, hey, this is our offer, I think that you can end up having an agreement that you don't like. I like to have a starting point personally. And I also just think that if you're going to have business terms or something like that, sale of a business, I think having some more stipulated terms to kind of go in with is really helpful. I mean, yeah, like I said, I'm team more prep rather than less, but I just think that it's a really long day. Like I tell this to everyone, you just can't understand how long and hard mediation is until you do it. And so I think that having more is always better. But
yeah, the team no prep sounds like a lot of fun. It sounds kind of nerve-wracking. But yeah, I mean, obviously going in there prepped is beneficial to everybody. I mean, because to your point, if I go into mediation and let's say we're respondent, and just for the people out there who don't know, typically the party who's the petitioner, whoever filed first, they're typically going to be sending the first offer in mediation. And I've been, we'll go in there and mediation starts at 9 a.m. and it's 11 a.m. and I still don't even have an offer. It's not only is it frustrating because you're losing valuable time, like you say, but you're also not accomplishing anything. It is, I mean, I'm sitting there with my clients, and don't get me wrong, love my clients, but they probably don't want to just pay me to sit there and talk about things that we've already talked about.
No, they definitely have friends they like better who don't charge them to hang out with them.
I would hope. I mean, I don't, it's probably debatable, but,
It's really frustrating, I think, when we go in and we don't get offers until 11 or so. Another thing that really bothers me is when we get, like, I know everyone makes a crazy first offer, but offers that are just really unrealistic because it's just, to me, it wastes time. I think we all know pretty well what we're willing to kind of settle for going into a case. And so I just don't really see the point of kind of spending time on something we know the other party's not going to agree to.
No, I hear you on that, but here's the problem. It happens every time. Every time. One side will send some absurd offer. We'll send some insane offer that both sides know neither side's going to agree to. But it is part of this song and dance of negotiations and, oh, well, now we came off this so much sort of deal. And it's like, yeah, but your first offer was ludicrous. Shout out to Luda.
I know it's crazy to me how it works. I mean, we all get those offers, but yes, I agree. I know there is a team no prep. I don't advise joining that team. It does sound nice, but yeah, that's
Sounds
another
like just chaos. It sounds like you're drinking beers the night before. Yeah.
Yes, I don't know what they're doing over there, but yeah, I mean, I think that there's definitely a world where we can all be more efficient because I can tell you the number of times I've been in mediation until 8, 9 o'clock at night, and I just think that we could eliminate that a little bit because it is a long time and long day for everyone.
Yeah. I mean, I think what it really boils down to is hopefully everybody's prepped. I would love, I don't know how to do this, but I would love to fast forward these mediations to about 4 o'clock and just say, here's my 4:30 offer. Let's just get this done. But that can never happen because everybody wants to send their initial offer, which no one is going to agree to. And, I've started at some point in these mediations. That's what I'll tell the mediator. I'll say, hey, this is my 4:30 offer. This is our final offer. We're not budging off of it. And of course, the other side will then want us to budge off it. But, trying to fast forward things is sometimes beneficial because it saves everybody time and money. But I think that can only happen when both sides are prepared. And, like you said, I always try to have client meetings, at least a few days out from mediation, go over the spreadsheet, make sure that clients understand, hey, here's our initial offer. And I do the same thing with my clients and I have them list a couple things. I have them list what their goals are, what their kind of minimum that they're going to take, and what their shooting for the stars offer is, which we would call our initial offer, because I want them to know, like, hey, here is the bare minimum of what you will agree to. And that way they go in with expectations of, hey, we can give up on this, we can, horse trade this for that sort of deal. And that does give clients at least a semblance and a realistic expectation of going in of what they're going to be giving up and what they're shooting for and things like that. So, I think, and every client asks me going in on these prep meetings, I get a standard questions of, how can we sway the mediator in our favor? I'm like, there's no swaying of the mediator. The mediator is literally just going back and forth between two rooms and conveying offers. And, a mediator is supposed to be a neutral party, and their job is just to get a deal done. And I tell clients, look, mediator is going to go into our room and tell us, here's your risks and here's why you should settle. And they're going to do the same thing in the other room. And so it's important for clients to kind of know what to expect on that. The mediator is not a judge. You don't need to present evidence to them. I mean, certainly people will do that and say, here's why I'm doing X, Y, Z. And if you need to, great. But, I think for the most part, it should be let's convey our offer. Here's a little bit of facts backing up why we're doing it so that they convey that to the other side and then kind of go from there.
Yeah, I agree. I think that a lot of times it can feel like a mediator is taking sides. I don't think that that's usually true. I was going to talk to you about this too. I think that's overlooked a little bit sometimes when prepping clients. I'm trying to focus on this more myself, is the ancillary issues outside of just like the spreadsheet, talking about like refinancing the house or, car loans, boat loans, things like that, the debt load, all of that. Like, I feel like kind of have to open the door to clients and say, like, outside of just the property division, like, what do you need to get done so we can include those terms? Because a lot of times I feel like people want to come in and negotiate those after the fact. And we don't really have the ability to do that easily or the leverage really to do it at that point. So I think another good point for clients is to think through those kind of beyond just the spreadsheet issues.
Yeah, and touching on that, I've seen it countless times, and I've seen attorneys that are guilty of this. And I don't like to reveal all my tricks here, but for those podcast subscribers and for those people who have made it this far, I feel I should at least give them a tip. Is you've got to look at, when you're doing property division, you need to make sure you're taking into account tax effects of things. And
Yeah.
neither you or I are tax attorneys, and nothing in this podcast is to be construed as tax advice. But, looking at 401k versus a brokerage account, 401k is a pre-tax account. That brokerage account, or that, savings account, that's going to be, that's post-tax money. Brokerage account, what happens if there's a bunch of capital gains or capital losses? How that's split up is, you can be talking about literally tens, hundreds of thousands of dollars in taxes that are either left on the table or ignored one reason or another.
And we see a lot of the small businesses who have filed extensions on their tax returns haven't filed, like looking down through like October as the extension deadline. So it's important on your overall tax treatment too, if you're not just a straight up W-2 employee and you're withholding, like to consider how you're going to handle your taxes for the year of divorce, because you don't want to be staring down the barrel of a huge liability. Like I always tell clients, if they have a CPA, it's a good idea to have that conversation before mediation. Business attorneys too, like if you're in a partnership or an LLC or something like that, good idea to have your business attorney weigh in on what your options are. Because also another thing is, like with businesses, a lot of times we've already gone through the process of assigning them a value and all these things, but sometimes there's some red tape on how we can transfer those interests or what we need to do where that's concerned to make sure that everything gets buttoned up there. So I feel like that's a good idea to just get that opinion going into mediation so you know what you need from the other side, because it's just difficult to do that after the fact. Like if we get a mediated settlement agreement, to go back in time and do that, it's hard.
And as we kind of joke about it, we're not tax attorneys, we're not giving tax advice, but it's true. And when you're in mediation, I'm going to tell my client that too. I say, look, I can't give you tax advice. That is outside of my realm. And so, whether, to your point, having the conversation with the CPA beforehand, have them available during the mediation to say, hey, here, we're thinking about doing this or doing that. Because, same with a house, if you're going to take a house and then sell the house, you're going to be hit with some taxes on that.
Yeah.
There's all these different hidden tax liabilities or even benefits. I've seen people try to kind of pick the stocks in a brokerage account that they want because those stocks have lost a bunch of money, and they give the ones that have gained a bunch of money to the other side. And on paper, it looks like the two stocks are worth the same amount. But realistically, the second they're sold, one party is going to get hit with the gains and the other party is going to get hit with the losses, and they're not hit with losses, but at least can claim the losses. And so, things like that are important to talk about.
And there's some kid issues, I think, that factor into that too. We talk about this, but like depending on your summer schedule, for example, like summer camp is a huge expense. If you're going to do a schedule where, most people do kind of these like bigger blocks of time in the summer, but if you're doing a schedule where y'all are going back and forth during the week at all, sharing the cost of summer camp might make sense. I think this is a great one all the time, but I have young children. You got young kids. We can talk about this, but the cost of daycare is so expensive. A lot of times like child support, we're looking at that number and saying like, how are we going to make this work? And I feel like, one of the great creative solutions that we have is not necessarily raising that child support number, but agreeing to carry some of those expenses while the children are young, like sharing daycare costs until they start kindergarten, or sharing the cost of extracurricular activities. We have some kids who are incredibly talented who are involved in a lot of extracurricular activities that are really expensive, and working out those agreements ahead of time can help if those kind of things are really important to your kids, just to make sure it fits with the session schedule and everyone can afford it and participate in it.
I've seen it countless times with travel teams and things like that. That stuff can get extremely expensive. And
And that kind of cuts through like first right of refusal. We see that a lot where people want a first right of refusal, meaning if the other parent can't take the kid during their time, they offer it back to the parent who's not going to have possession. We got to think through too, like my kids stay with their grandparents a lot because we live close. You want to make sure you carve out those exceptions that are important to you and important to your kids. So those are all things to think about, I think. Just make sure you're kind of considering your lifestyle going into mediation and kind of those ancillary too.
I think the right of first refusal is such a terrible idea.
I totally understand why people do it. And I think maybe if someone traveled, I think about this, I'm like, maybe if someone traveled a lot for work, that would make sense. If you're going to have like random Tuesday and Wednesdays during the school year or something like that. But yeah, overall, I think it's really cumbersome. And as your kids get older, they're going to want to go to sleepovers
But then the enforceability of it, virtually impossible.
yes. And then what if like the parent says they can take them? This happens all the time, right? It says they can take them and then it gets to be the week that they're supposed to have them and they're like, oh wait, no, I can't do that.
Just causes more problems and something that can be mediated. And I think that's a good place, a good stopping point here.
Well, thank you so much for having me.
Well, thank you for joining me. And it was good times. You crushed it.
Oh, thank you. I feel like I could talk about mediation for probably 3 hours. Like there's so many things to say about it, but
maybe if people smash that like button on our podcast, we'll get a part 2 of this. I don't know. We'll see. And we'll reveal more tips, insider tips there.
Yes,
so,
if you make it through the first 20 minutes of our podcast, we promise to give you our good tips.
And that's the thing, you have to, but maybe we need to change it up so that they just don't fast forward to the 20-minute mark. So that's the key.
Maybe we need to mix it up next time and give the tips at the beginning.
Everyone out there, you don't know where the tips are going to be, so you're going to have to listen to the whole episode.
Listen to the whole thing.
So, all right, that's all we got today. Thanks, Jessica, for joining us.
Thank you.
If you have any follow-up questions on mediation or are interested in consulting with myself, Jessica, or any of the attorneys here at Walters Gilbreath, feel free to contact us directly. You'll find the link to our website as well as our contact information. I'm Ryan Segall, and thanks for joining, everybody.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.